everyone. So we are here again, and this will be the part 2 of the latest landmark judgments. So I hope you guys have watched the earlier video, that was the part 1, which was related to all the landmark judgments held in 2021 to 2022. So all these judgments are important for your examination purpose. So whether you are preparing for a DULLB, CLAT, NLS 80, so this will be directly or indirectly helping you. So, and again, I'm repeating it again. It would be difficult for you to remember the name of the case laws and the judgment. So try to choose the keywords. So let's begin. Let's begin with the first case. So today we are having Lakshmi Bai Chandragiri versus state of Karnataka. So in this case, what happened was, so basically, first of all, remember that this case is related to Article 21, that is right to life, which includes freedom to marry. So now we are having a freedom to marry. So now adults can marry anyone and no one can restrain them, not even your parents. So consent of family not needed once two adults decide to marry. So in this situation, the court observed that educated younger boys and girls are choosing their life partners, which is departure from traditional norms of society. And again, the consent of family, community or clan is not necessary for two adults individual agree to enter into a wedlock. So now their consent has to be given primacy. So basically parents cannot interfere. So recently you might have witnessed a lot of judgments regarding that. So you can remember Article 21. Okay. Now moving further, the second case we are having is the Chief Election Commissioner of India versus Mr. Vijay Bhaskar. So now in this situation, what happened? Now this case is related to Article 19 Clause 1 Clause A, which talks about freedom of speech and expression. So now freedom of speech and expression also includes freedom of press, right? So freedom of press relating to court proceedings. So in this situation, court held that freedom of speech and expression also extends to reporting the proceedings that happens in court, including oral observation made by the judges. This is also one of the important judgment. The next judgment we are having is Jayama versus state of Karnataka. So now this case is related to dying declaration, which falls under Indian Evidence Act. It is a type of evidence. Now, so Supreme Court recently held that basically dying declaration can be considered to be a sole evidence for prosecuting a person. The Supreme Court held that dying declaration are admissible in evidence on the principle of necessity, as there is a little hope of the maker surviving. So now dying declaration can form the basis of conviction of recorded in accordance with law. So now law means the Indian Evidence Act. So as per that particular law, conviction will be done. And if moving further, it is given a cognate and the possible explanation of the occurrence, it can be relied on as the solitary piece of evidence. So basically, dying declaration as a sole evidence we can consider. So the next case we are having is Muhammad Salima versus Union of India. So this case is related to, so you might have seen in the news basically. So basically Muhammad Salima basically filed a case challenging the deportation of Rohingya Muslim who had taken refuge in India to escape persecution in Myanmar. So basically after that, Supreme Court held that right not to be deported basically falls under Article 19 and only it's available to Indian citizens. Now, this is again one of the landmark case, Anuradha Bhashin versus Union of India. So this is related to right to internet, and in this it was held that right to internet basically falls under Article 19A of Indian Constitution. Okay? So basically what happened when there was an internet ban in the state of Jammu and Kashmir due to Article 370. So that time actually the Indian government banned the internet for a very long period of time. So that time case was filed. So court held that ban on internet services in the state of Jammu and Kashmir is unreasonable and violative of the above mentioned article, that is Article 19 plus 1 plus A. The next landmark case is Mukesh Kumar and others versus the state of Uttarakhand and others. This is actually a very landmark case related to reservation under Article 16. So the present judgment made a settled law that the state government cannot be directed to provide reservations for appointment in public post and is not bound to make reservation for ST/SC in manners of promotion. Thus, an individual cannot claim reservation as his fundamental right. So now, although reservation falls under Article 16, Article 16 is our fundamental right. But as we know that कि कोई भी fundamental rights हमारा absolute नहीं है. So in the same way, asking for reservation or promotion in reservation is not a fundamental right. So basically, it is the discretion of the state government to decide whether reservations are required in appointments and promotion. So there is a whole guidelines which has been laid down by the Supreme Court, and this is actually very important. Next, Prithviraj Chauhan versus Union of India. So now this case is related to ST/SC. So in this case, the court in this judgment tactfully upheld the constitutionality of ST/SC Act. So the amendment was brought forth to reverse the Supreme Court judgment. So the Supreme Court passed the judgment, and because of that only the amendment was done that introduced safeguards that prevented the misuse of ST/SC. So Amish Devgan versus Union of India. So now this case is related to hate speech. So in this case, Supreme Court emphasized the importance of protecting free speech, basically which falls under Article 19 Clause 1 Clause A. So protecting free speech while also protecting group dignity and the unity of the nation by prescribing speech which threaten the dignity and unity. You might be witnessing a lot of hate speech right now, and the case is being filed. So whenever you say anything against the religion, so this is also considered to be a type of hate speech only. Next is again very important judgment, Internet and Mobile Association of India versus Reserve Bank of India, which is also known as cryptocurrency judgment. So it is known for the Supreme Court decision to lift the restrictions imposed by the RBI on regulated entities dealing with virtual currencies. So basically what happened, RBI brought a notification which actually banned the regulated entities such as bank and the financial institutions from dealing with virtual currencies such as cryptocurrency, bitcoins and etc. So what happened was Internet and Mobile Association of India challenged the RBI notification. So not to restrict banks and financial institutions from providing access to the banking services and transactions that are linked with virtual currencies. So the court validated the ground of proportionality by settling aside the circular issued by the RBI, preventing regulated entities from providing banking services those engaged in the trading or facilitating the trading in virtual currencies. And recently also Nirmala Sitharaman banned the dealing in private cryptocurrency, and now RBI will be dealing with that. So they are trying to make a regulated body which we don't have till date. So the next case we are having is Gautam Navlakh versus National Investigation Agency. So now, simply in this case, it was held that the bench accomplished this by allowing courts to order house arrest as a form of custody in appropriate instance under section 167 of CRPC. Now, section 167 basically deals with procedure when investigation cannot be completed in 20 days. So in this situation, house arrest can be done. And house arrest कब किया जाता है? So basically this is first of all an official order that you're not supposed to leave your home when they suspect you that you are involved in illegal activities. Moving further, Mohit Minerals versus Union of India. So in this case, GST Council's recommendation, it was held that GST Council का जो recommendation is not binding on the center and state, and those have only persuasive value. The Supreme Court ruled in the landmark judgment while striking down the integrated GST levy in an ocean freight case. So now my question to you guys is, when GST provision was added in the constitution, by which amendment? I would request everyone to comment on the comment box. So the apex court further said Parliament and the state legislature had equal powers to legislate on GST, and council must work in harmonious manner to achieve workable solution between the center and the amendments. So now you're having one question. So by which amendment GST was added? Okay, so supposed to answer this. Let's see. Okay, so the next case we are having is Municipal Corporation of Greater Mumbai versus Ankita Sinha and others. So in this case, simply it was held that NGT, National Green Tribunal, has power to take suo motu. Suo motu means on its own cognizance of environmental issues, even though the National Green Tribunal Act 2010 does not expressly provide the NGT to take suo motu cognizance. Next case we are having is Northern Western Railway versus Sanjay Shukla. So the Supreme Court basically held against the Indian Railways that they're supposed to pay compensation to passengers if trains run late. So highlighted, Supreme Court slammed Indian Railways for delayed running of trains in order to pay a compensation of rupees 30,000 to a man who missed his train because of the delay. Moving further, State of Haryana versus Rajkumar. In this case, it was held that governor of a state can pardon prisoners, including death row ones, even before they have served a minimum 14 years of prison sentence. So 14 साल से पहले ही. So basically it overruled section 433A of CRPC. So section 433A of the CRPC mandates that prisoner sentence can be remitted only after 14 years. But Supreme Court ने, but basically State of Haryana ने क्या held किया कि गवर्नर के पास पावर है. So सुप्रीम कोर्ट ने हेल्ड किया कि गवर्नर के पास पावर है कि बिफोर 14 ईयर्स, ठीक है, उनको रिमिट कर सकता है. So again the next case, Paramveer Singh Saini versus Baljit Singh, very landmark case. In this case it was held a very unique and avant-garde judgment mandated installation of CCTV camera in all police stations as well as other investigating agencies like NIA, CIB, NCB, etc. The Honorable Court ordered that in any circumstances that reflect human rights violation, the victim has a right to obtain a copy of CCTV footage of the interrogation and can approach the National or State Human Rights Commission for the same. So the installation of CCTV has been mandated in any office that has the power to arrest and integrate an individual. So the last case we are having is Roe vs. Wade. I'm sure this case you might have heard a lot because this was in news. So this was first of all a landmark decision of the Supreme Court in which court ruled that the Constitution of United States conferred the right to have an abortion. So two important things was held in this case. First of all, that this is a right to privacy that protects a person's right to choose whether to have an abortion. The second thing was, but the abortion right was not absolute it must be balanced against the government's interest in protecting health and prenatal life. So finally, so what's the current decision? Recently, this decision has been overruled by the Supreme Court of the USA. So the landmark judgment given by the Supreme Court has been overruled. So I hope this would have been helpful for you guys, and thank you so much. All the best. We will be continuing with the judgments, the next series of the judgment. Thank you everyone.